Welcome to the Equity and Trusts class. Maxims of equity are legal maxims that serve as a set of general principles or rules which are said to govern the way in which equity operates. They tend to illustrate the qualities of equity, in contrast to the common law, as a more flexible, responsive approach to the needs of the individual, inclined to take into account the party's conduct and worthiness. There are more than one legal maxims that are individually discussed in equity and trusts law. Can you guess which legal maxim we are going to explain today? We are going to share about equity is equality. The maxim expresses the object of both law and equity in order to effectuate a distribution of property and losses proportionate to several claims and liabilities of the parties concerned. Equality therefore means proportionate equality. Equity has been able to apply this maxim in numerous ways. Some of them are 1. Presumption of tenancy under common law, 2. Severance of joint tenancy, and 3. Equal division. Presumption of tenancy. Under common law, equity introduced the concept of tenancy in common. The concept of tenancy in common means that when one of the joint owners dies, in equity, the surviving owner holds the property in trust for the beneficiary of the deceased owner. For example, Jimin and Chenil both contribute towards acquiring a piece of land. If Chenil dies, Chenil's representative, this could be his wife, or whoever inherits his estate, would have a right to Chenil's interest in the property. As a result of the tenancy in common, Jimin would be presumed to hold Chenil's interest in the property in trust. For Chenil's representative, equity presumes tenancy in common in 3 broad circumstances, which are purchase in unequal shares, loan on mortgage, and partnership. Next, severance of joint tenancy, where the parties purchase the property in equal shares. It would be regarded as a tenancy in common under law. However, where one of the parties alienates his own portion or interest in the property, the courts would take it to mean that the joint tenancy has been severed. In the case of Ipe versus Arabizala 193010 Lir. 10. The plaintiff's mother left her property to him and his brother in equal shares. As a result, the common law doctrine of joint tenancy applied to the shared property in question. However, the brother of the plaintiff died intestate, and the plaintiff discovered that his brother had already used his own portion of the property as security for a loan. The court held that by mortgaging his portion of the property, his brother has alienated his right in his own portion of the property. As such, the plaintiff could not control the entire property by virtue of joint tenancy. In essence, the alienation of the property by his deceased brother had severed the joint tenancy in operation between him and the plaintiff. Lastly, equality division occurs in a situation where a property is to be divided and there is no clear-cut legal basis for the division. Example in the case of Maynard v. Jones 1951 ch. 572, where a husband and wife both jointly operated a bank account. They regularly deposited different sums of money into the account. When the couple divorced, the court had to decide how the sums in the bank account would be divided. The court applied this maxim in such as the property was divided evenly between the husband and the wife. The conclusion: equity always tried to keep the parties at the same position. A party cannot get any undue advantage over the other. The doctrine of equality, however, operated more effectually in court of equity than in the court of law. Thank you for watching. Bye-bye.